jūs visus matyti taip gausiai susirinkusius šiame renginyje, kurio tikslas aptarti JAV muitus arba tarifus, kaip jie plačiau ir populiariau vadinami čia Jungtinėse valstijose. Renginį Užsienio reikalų ministerija organizuoja kartu su Inovacijų agentūra ir su Niujorke įsikūrusiais Baltijos Amerikos prekybos rūmais. I will now switch to English to welcome and introduce our presenters today, Dave Townsend and Augustine Lo, both from Dorsey and Whitney LLP. I understand they only have an hour to spend with us, so without further ado, I would just suggest to start right away, and we'll start with their presentation. And then following the presentation, we will have 10 to 15 minutes for questions and answers. So please, everyone, use the YouTube channel to post your questions. We will get those questions to us, and then at the end, I will try, time permitting, to ask some of them. Thank you very much again for joining, and now over to you, Dave and Augustine.
Thank you for this opportunity to speak with this distinguished audience today. I am Augustine Lo, a partner in Dorsey and Whitney's National Security and International Trade Practice Group. By way of background, I used to be an attorney at U.S. Customs and Border Protection, which is the U.S. government agency that administers the customs laws, including the tariffs that we're discussing today. So that is it's an agency within the Department of Homeland Security. They're responsible for investigating as well any potential compliance issues. In addition, my practice includes advising clients on U.S. export controls under the Export Administration Regulations and the International Trafficking in Arms Regulations, sanctions regulations administered by the Treasury Department's Office of Foreign Assets Control, as well as review of foreign inbound investments into the United States. Previously, I also worked for the U.S. District Court in Puerto Rico briefly after law school and before joining practice. Dave?
Yeah, thanks, Augustine, and thank you to the Lithuanian consulate in New York and the chamber, the Baltic Chamber, for teaming up today to present this to you all. We're very pleased to be joining you and providing an overview about U.S. trade policy and what has happened to date, and some things that we've seen that can help companies navigate and mitigate their risk of tariff liability in the current environment. So my name is Dave Townsend. I'm also a partner, work with Augustine in the National Security Group and Government Solutions and Investigations Group here at Dorsey and Whitney. I've been a practicing trade attorney for a little over 15 years. I focus on international trade disputes, trade remedies proceedings, tariff litigation, and tariff compliance matters, as well as export controls and economic sanctions. So we're going to start the first half, maybe a little more than half of our presentation this morning is going to be focused on what the Trump administration has done thus far in terms of U.S. trade policy. It's hard to believe that the Trump administration has not even been in office yet for 2 months, given the amount of changes that we've seen. And Augustine and I sort of joke that when we're getting ready to provide updates like this, either in presentation or written form, we typically wait until the day before, because anything we do in advance tends to be obsolete by the time the time comes to actually give it. So in terms of an introduction and what we're going to talk about, we're going to talk about the tariffs that have been imposed thus far, as well as a couple of investigations that have begun that signal where things are headed, and sort of the framework under U.S. law for new tariffs to be imposed, as well as some of the timelines on which tariffs can be imposed. One of the themes you're going to see through the course of the presentation is that the tariffs are being imposed in connection with highly politicized issues such as illicit drug trafficking, immigration, and perceptions of unfair trade. and that President Trump himself has made himself really the sole decider of these issues, which makes them prone to sudden change, and allows him to impose tariffs sometimes the day of him making a decision as to a particular issue. And that's why we've seen a significant change thus far. The second half of our presentation, we're going to go over some tariff mitigation strategies that we have that we can provide based on our advice to the private sector and companies who are dealing with these tariffs. You know, one thing I'll say about Augustine and my practice is that we do advise companies in all different sectors, and the tariffs, the way they're being imposed, have an impact in a wide variety of sectors. So it's not really focused to a particular industry or sector. It's pretty broad-based right now, and so necessarily our discussion of tariff mitigation strategies will be very high level and non-specific to any particular company or sector. So with that, we'll get started with what has happened thus far. I'm going to cover a couple of sort of framework things that President Trump has done before we go into the specific tariffs that are now in effect. So on President Trump's first day in office, he issued the America First Trade Policy Memorandum. This memorandum is really a framework for directing the entirety of U.S. government to reevaluate U.S. trade policy. It's framed as a focus on reciprocal market access. It talks about a potential global supplemental tariff, which to date hasn't been enacted, but remains possible. And just to give you a flavor for some of the bases for potential tariff action, this memorandum highlights large and persistent annual trade deficits. So the U.S. importing more from trading partners than we export to them, which is perceived as a problem from the White House. This memorandum also highlights alleged unfair trade practices by foreign countries, such as subsidies or unfair pricing. Talks about sort of a top to bottom review of U.S. free trade agreements, including the U.S.-Mexico-Canada agreement or USMCA, exchange rate imbalances, as well as a variety of other issues, including some China-specific, a focus on China specifically, as well as national security and border security issues. And as we'll see, those latter issues have already become a basis for new tariffs in the United States.
Thanks, Dave.
I'm sorry, go ahead, Augustine. Yeah.
I was going to move to the next section, but sorry, just cut you off.
No, go ahead, Augustine, if you want to kick off the reciprocal trade policy.
Sure. Thanks, Dave. Oh, we should add a note here that this discussion today is not meant to be legal advice for anyone in the audience. If you have specific questions, we'll be happy to take them after the call. So as for reciprocal tariffs, as Dave had previewed, the Trump administration issued this memorandum on February 13th on what on specific concerns that the United States government has had with respect to major trading partners. Next slide, please. And this potentially sets the ground for further trade actions that may be in addition to what we have already seen. So potential areas for grievances include tariffs imposed on U.S. goods by foreign countries, discrimination against U.S. goods imposed by other countries, taxes imposed by other countries, but that includes VAT taxes, right? So VAT taxes imposed on U.S. goods in other countries may become a source of a grievance. The cost to U.S. businesses from non-tariff barriers, policies and practices relating to exchange rates, as well as any other policies and practices that the U.S. trade representative may find to harm U.S. products, goods, in terms of competition for exports. There is an ongoing process that has just concluded. There was a public comments process that just concluded as of yesterday. So the United States Trade Representative is now assessing the public comments relating to these alleged practices and will issue a report that is due April 1st to the United States, to the U.S. President Trump, and then they shall decide what tariff action to impose to address these grievances that they have uncovered through this process. There's not a specific time frame for the imposition of those tariffs per se, but that report is expected to be issued in about 2 weeks. Other tariff actions that you may have heard in the news include the Section 232 tariffs, which are national security tariffs the United States has imposed during the first Trump administration a few years back, and were retained during the Biden administration, and recently expanded to now include EU origin goods. The tariff rate is 25% for both steel products as well as aluminum products and derivative products. And guidance was issued just yesterday, noting that importers of these products into the United States will now have to report separately the steel or aluminum content for certain derivative products containing those things, so that customs can assess the 25% tariff on the content of the aluminum or steel in those products. This is a departure from past practice, and it will be interesting to see how this rolls out, as it creates significant burden to the reporting process for imports into the United States. So the reason why this is now pertinent for the EU is because until yesterday, the United States have for several years exempted EU origin goods, as well as goods of certain other allied countries, from these tariffs. But about a month ago, the Trump administration announced its intention to stop these exemptions, believing that it was necessary to expand the tariff action to include all countries, all sources, so that it would correct the deficiencies or the problems the United States government believes to exist with respect to importations of these goods that impact the U.S. industrial base for production of strategic metals. Another thing to note about these tariffs is that they are imposed on the basis of tariff classification codes. So those codes are specified in the tariff actions and the implementing regulations. It is important to consult those provisions to see whether or not an imported product could be subject to those tariffs. And relatedly, as we shall discuss later, it is also important to review the tariff classification of imported products to ensure that they are accurate and that customs may not believe that there may be any compliance issues leading to underpayment or avoidance of those tariffs. Another aspect of the tariff is that it is possible to exempt U.S. origin steel or aluminum that's smelted originally in the United States and processed in third countries. So that could create an incentive to reporting the content if it is possible to show that steel or aluminum originated in the United States. And there's a URL there below to a recent update that we issued on these tariffs.
Yeah, and Augustine, I mean, one thing about these tariffs that is noteworthy for the audience here is that two things. One, that the tariffs apply to EU goods, which they didn't, as you noted prior, based on an agreement that had exempted EU origin steel and aluminum from the Section 232 tariffs. And then second, they were expanded to cover, they already covered some derivative articles, but even more derivative articles than were covered in the past. So new steel and aluminum items imported into the United States became subject to the tariff regardless of origin as a result of that action.
That's right. In addition, with President Trump's proclamations, recent proclamations expanding these tariffs, there is also a plan to create a new process by which U.S. companies could request the addition of more derivative articles, steel aluminum articles, to the list of tariff products. So that will be, we'll have to see how that rolls out. So that could be forthcoming, where there will be a public process by which U.S. companies could request the addition of more derivative steel and aluminum articles to the tariff list, subjecting those goods, imported goods, to these 25% tariffs.
Okay.
Yes, and I believe now that we're ready to discuss the Canadian, China, Mexico tariff action.
Yeah, and so to give you the full picture of what's happened, we're going to briefly cover the new tariffs in the United States on Canadian, Chinese, and Mexican goods. These tariffs are unique and unprecedented in the United States because they were done under IEEPA, or the International Emergency Economic Powers Act. And IEEPA has been a basis for sanctions for a long time. For instance, IEEPA-based sanctions are primarily how the United States has restricted trade and investment with Russia and other sanctioned locations, but IEEPA hadn't been used as an authority to impose tariffs until President Trump did so over the last month and a half. And so what President Trump did, he declared an international emergency with respect to drug trafficking and illegal border crossings, and then used that as a basis to impose sanctions, to impose new tariffs on all three of these countries. The China tariffs were increased by 20%, covering all imports. And those are in addition to the existing tariffs on Chinese origin goods into the United States, which covered a lot of products at a 25% rate or a 7.5% rate. Although there were some products that weren't subject to either the 25% or 7.5% rate and have now become subject to the 20% rate, which applies in addition to everything else. With respect to Canada and Mexico, there's been a lot of back and forth and changes in these over the last several weeks. But where this came out was that the United States now imposes a 25% tariff on imports of Canadian and Mexican goods, unless those goods qualify under product-specific rules of origin that are set forth in our trade agreement with those countries, what we call USMCA. And there's also a carve-out for imports from Canada of energy products and potash, which are at 10%. And so what you see is there's a big incentive now for companies in the United States, if they're importing products from Mexico and Canada, to make sure they can prove to U.S. Customs that their goods qualify under the USMCA for preferential treatment, because then that will allow them to continue often entering the goods duty-free. Now, one thing about that carve out for USMCA goods is that's going to be reevaluated in April. President Trump agreed to delay tariffs on USMCA or originating goods, but only for 1 month. So presumably we're going to be looking at this again in April, perhaps aligned with whatever decisions we see with respect to the reciprocal tariffs, which Augustine summarized for you earlier.
Dave, so to go back on, to a question about this tariff action on Canada, China, and Mexico, was there also some discussion of the treatment of de minimis exemptions for small parcels?
Yes, right. So originally the Trump administration proposed to remove the de minimis exemption for China, as well as Canada and Mexico. The the decision to whether or not to do that has been sort of deferred for now. And the US government is basically trying to figure out logistically how it could administer getting rid of that exemption. That exemption, what it does is it allows parcels or packages to come into the United States without having to go through customs formalities and formal customs declarations if the package is valued at $800 or less. And the theory being that it wasn't worth the administrative effort to apply tariffs and other customs formalities to products that were of such lower value, and also that it could boost e-commerce by permitting that that exemption to exist. It's been problematic in the United States to allow imports to come in under the de minimis exemption, primarily from China, because of the high tariff rates on Chinese origin goods coming into the United States. People were saying, well, so much of what China ships to or a good chunk of what China is now shipping to the United States is just coming in duty-free under the de minimis exemption, that it became a subject of scrutiny, not only on Capitol Hill, but in the Biden administration, as well as now in the Trump administration. So we do expect significant changes in de minimis and when companies can use it. But I know, Augustine, that's something you've been following closely. You have anything to add on that topic?
Sure, Dave. So as the rollout process was less than smooth, right? So when the Trump administration announced this provision as part of the proposed intended tariff actions under IEEPA against Chinese, Mexican, and Canadian goods, it doesn't seem like they had a very smooth rollout process, and so had to pull back within 2 days, probably because Customs was not prepared to actually process these parcels that were previously exempt from reporting for most purposes. They didn't have to scrutinize them as much. They didn't have to collect tariffs on them. And all of a sudden, they had to do so for this massive influx of parcels, and they were not prepared to do so. And so they suspended that this aspect of the tariff actions. However, we will note at the same time, Customs has been considering an expansion of a version of this before it was surprised basically by the sudden imposition of this tariff action, that they were contemplating potentially removing the availability of de minimis exemptions for parcels that could be subject to certain tariffs. This has not happened in the past. So previously, and currently still, it is possible to import parcels that contain steel and aluminum derivative articles, for example, that could be subject to the Section 232 tariff. But if it's below the $800 per day amount per person, then that parcel may not be subject to customs declaration and the payment of that import tariff. However, under these proposals, which may roll out anyway, whether or not the Trump actions take place, or that provision of the Trump tariff action takes effect, Customs is contemplating scrutinizing these parcels so that future deliveries of small parcels under $800 containing certain derivative steel and aluminum articles, including those from the EU, may become subject to reporting and to the tariff.
Right. Yes. Thank you. And to get back to the kind of the bigger picture here, our takeaway, or a few takeaways, I think, for this audience with respect to what's happened with Canada, Mexico, and China. Obviously, it could impact your operations if you're purchasing things from China and further working it before sending it to the United States, but also just that the decision-making process makes it difficult, if not impossible, to predict what's coming next. These tariffs, again, were introduced under IEEPA, which allowed immediate imposition of tariffs as a result of the executive orders that the White House put out. And President Trump has said that he intends to issue additional tariffs with respect to the EU soon. There's also other countries of concern Malaysia, Thailand, Vietnam, because of them acting as hubs to avoid the China-specific tariffs that are in effect. And so we provide in this slide, there's a link to a summary of the tariffs on Canada, China, and Mexico that we put out recently. So there also, I think it was last week or within the last 2 weeks, there were new Section 232 investigations initiated. So Section 232, you want to think about as a product specific or industry specific investigation. So the prior investigations of the Trump administration allowed the imposition of duties on steel and aluminum, as we just discussed. These are new investigations which are looking at imports into the United States of copper and timber. These were, again, initiated at the direction of President Trump himself, rather than a domestic U.S. industry asking for Section 232 investigation. If you look at the aluminum and steel investigations that took place during the first Trump administration, those tariffs continue today. And so these new investigations are important if you're operating in sectors that could be impacted, if you have copper products or products that are derived from timber. In terms of the lessons learned from those prior cases, obviously, the steel and aluminum tariffs have been expanded to cover things like steel nails, like extruded aluminum, and other imports into the United States, depending on their tariff classification. And so if you are dealing with things like paper, cabinetry, furniture, wood, or have to rely on copper for production of products that are going to the United States, you're going to want to keep an eye on this. It seems likely, though not certain, that U.S. restrictions will result from these investigations. Presumably, my guess is they will, because otherwise, why would the White House be directing the initiation of a new investigation? But that's not certain. There was, for example, a 232 investigation on automotive or vehicles and automotive parts in the first Trump administration that never resulted in tariffs. This will take some time before trade restrictions come into effect, because there is an administrative and an investigative process that has to be completed prior to recommendations being given. And then I think, Augustine, I'm going back to you to go into the next slide.
Yes, please. No, thanks, Dave. Yes. So you've heard Dave talk about the pending Section 232 investigations. So here is a summary of all the different laws that have been used or could be used to impose additional tariffs on imported goods into the United States. These are in addition to the general import tariff that most people consider, which is the most favored nations provision, basically, under the tariff schedule. So these tariffs would apply in addition to that base tariff rate. As at the outset, earlier on we discussed IEEPA. This is an unusual application of IEEPA to impose tariffs in the case of Canada, China, and Mexico. Before the Trump administration, this has not been used to impose tariffs. The statute itself does not provide for tariffs as an appropriate relief in the case as in response to international emergencies. But the Trump administration has asserted that power to use the statute to impose tariffs. The statute does not require prior notice and public comments or any investigation, and so it could be imposed immediately. Section 301 of the Trade Act of 1974, we also discussed in relation to tariffs that have been imposed on Chinese origin goods, a large section of them with various tariff rates depending on the tariff classification code. And these have been adjusted over the past year by the Biden administration for certain products to as high as 100%. There is an investigation period that has to investigation has been conducted, and the U.S. Trade Representative, or the USTR, generally consults public opinion or public comments, excuse me, from the industry and members of the public before issuing a report and before considering the appropriate trade action, the tariff action with respect to imported products. These Section 301 targets imports. Is meant to address unfair trade practices and actions that cause an unreasonable burden, some burden on U.S. commerce. And so the USTR has to find that has to make a finding that the other countries' policies and actions somehow burden U.S. commerce, and the tariff action is meant to address that grievance. And to obtain the removal of those issues. There is previously, under the first Trump administration, there was a Section 301 investigation potentially pending with respect to digital taxes for digital services from the EU, and the Trump administration had contemplated imposing Section 301 tariffs on many EU origin products. Those were suspended during the first Trump administration, but depending on how things go in the second Trump administration, it is possible for the current USTR to revive that trade investigation. Section 232 of the Trade Expansion Act of 1962 is meant to impose tariffs to adjust imports that threaten to impair the threat to harm U.S. national security. This was invoked during the first Trump administration with respect to global imports of steel and aluminum, which we just discussed. Initially, the Trump administration scaled back those tariffs with respect to close allies like Canada, Mexico, and the EU, in exchange for for restraints on exports from those countries. But as you had just heard, those exemptions ended as of yesterday, so the tariffs now are being imposed and expanded, including an expanded scope on imports across the world, including from the European Union. The Trump administration or the United States government takes the position that Section 232 is consistent with GATT and with the WTO agreements because it is a national security provision. And then there are some other provisions in the U.S. laws that could be used to impose tariffs but have not really been invoked. Section 122 of the Trade Act of 1974 potentially could allow the imposition of tariffs to address global imbalance of payments. Section 338 of the Tariff Act of 1930 potentially could authorize tariffs to address discriminatory actions by other countries against U.S. goods. Of course, the U.S. Congress could also enact new laws because under the U.S. Constitution, Congress has the plenary authority to regulate international commerce, including the imposition of tariffs, and also they have plenary authority over taxes. Finally, we have anti-dumping countervailing duties under existing U.S. law. We've deferred them to the last because with all the activity happening around sort of executive actions, these still exist in the background, but perhaps have taken a back seat somewhat. So historically, before the Trump administration's hyperactivity with respect to tariffs, U.S. companies could seek the imposition of anti-dumping and countervailing duties to address alleged unfair trade practices by foreign competitors. So anti-dumping is a theory of predatory pricing, whereby the goods of foreign exports are unfairly priced, lower than fair value. And then this countervailing duties, or is also called anti-subsidy duties in some countries, is meant to address unfair export-oriented subsidies that help the competing imports into the United States. Those also have a statutory timeline for an investigation that before the imposition of the tariff. Statutory timeline to investigate the appropriate margin to impose as the tariff on those goods. They target specific countries. So who could be next, right? So we talked about Canada, China, Mexico, and recently we've talked about expanded global imports for steel aluminum. It looks like the tariff actions closely track the U.S. trade deficits with its top trading partners. So if that is the route the U.S. government is taking, then many of the countries on this list, the top trading partners of the United States, could be up next for tariff action. As you'll see, many of these countries are parts of the European Union. And so it is very possible that the Trump administration will take some course of action with respect to the EU. Next slide, please. And it's unclear how long these tariff actions would endure. It appears to be part of the Trump administration's bilateral negotiation strategies because they like to negotiate on a bilateral basis, except in the case of the EU, because if it's a sort of common market and common exterior tariff, it would be interesting to see how the Trump administration deals with that fact and whether are any opportunities to actually deal bilaterally with members of the European Union, or if it's going to be an across-the-board tariff action to all member states. Other countries that could be targeted, our top trading partners include Japan, South Korea, Taiwan, and of course, the United Kingdom and Vietnam.
Yeah, I mean, I think one thing about the next steps here before we go into the strategies that we see as potentially viable for companies is from the EU's perspective with the reciprocal tariffs. I do think that there are a lot of different directions the reciprocal tariffs could go. Obviously, the EU as a common market has a common tariff on U.S. origin goods to the EU, all EU countries. And so that might suggest that whatever action we see will be on an EU-wide basis. But it is possible that the reciprocal trade action could result in something that is not done on a fully EU-wide basis. And if you look at the basis for action under the reciprocal trade memorandum that we summarized earlier, it goes beyond just tariffs. And so, you could reach into things like taxes or even administrative practices within a particular country that the United States deems distortive or unfair to U.S. business interests. And so I think there's a lot to be seen, remains to be seen as of April 1st when we get some sort of indication on what's coming next on that front. So with that, we'll do a brief summary. And Augustine, we don't have too much time if we want to preserve some for questions. So we'll go through these relatively quickly in terms of strategies that can be used to mitigate the impact of tariffs on your company or your business partners in the United States. One thing Augustine and I do for companies all the time is help them with compliance basics, such as tariff classification, country of origin valuation. Country of origin could be particularly important for people in Lithuania, for example, if they're processing metals that are purchased from other countries, then it creates a country of origin question when it's shipped to the United States as to how to declare the origin and then what tariff applies under these various authorities and tariff regimes that we've summarized. In terms of compliance, I want to point out that because of the increased tariffs, the compliance risk to any given company is increased, because if you get it wrong, you're depriving the U.S. government of more revenue, which creates a more significant basis for U.S. government action, not only to recoup the tariffs, but potential penalties that could arise. And with that, Augustine, I'm going to kick it back to you to talk about these other strategies, but maybe just say a brief word, given your background at CBP, about enforcement and what customs can do with respect to people who underpay tariffs.
Thanks, Dave. So customs enforcement is now split into two different agencies. After the September 11, 2001 attacks, customs was reorganized as part of the Department of Homeland Security. And so on the front end, you have U.S. Customs and Border Protection that collects import duties and investigate import declarations for potential inaccuracies. On the back end, should there be evidence of criminal violations, they could refer the matter to ICE, or Immigration and Customs Enforcement, for criminal investigations and prosecution by the U.S. Department of Justice. So, customs compliance is important because there could both be civil penalties as well as criminal liability in the case of intentional willful misconduct, or if they believe that there's evidence of intentional misconduct. So, important things to consider would be tariff classification, origin, and valuation, as Dave described, because those are key inputs for the accurate assessment of import duties. If those three key data elements are misreported, it could lead to underpayment, and so there could, at the minimum, be a claim for unpaid duties and civil liability penalty up to the value of the goods themselves. That's on the sort of monetary penalty. But also, of course, if it elevates to these to a intentional violation, there could also be criminal investigation and prosecution as well. So one of the things that Customs looks for carefully, scrutinizes, is whether there could be evidence of undervaluation through, say, misreporting of invoices, or perhaps transfer pricing between related companies. Sometimes because that could mask the actual transaction value, or there could be other things that should be added to transaction value that's not added to the value in the invoice. In terms of country of origin, they look for things like transshipment, whether or not a product that's really of one country could be shipped to a third country, and so therefore be inaccurately labeled and described as a product of a third country when it has not undergone sufficient processing to qualify as a product of that country, because many of these tariff actions are country specific. Right, that is a potential risk that CBP Customs looks for. But in addition to the trade zones, but yeah, at the same time, if a product has undergone sufficient processing in that third country, it could qualify as a product of that third country, and potentially correctly avoid that tariff liability. And so this is something to be thinking about carefully as you weigh options for tariff mitigation. Foreign trade zones in the United States is another potential option. These are special administrative zones set up so that goods that go into it are not subject to immediate tariff collection. And the benefit there potentially is if an importer expects a tariff action to be rescinded at some point in the future, then they could, and goods however are arriving just as the tariff action is taking effect, they could potentially send goods into those zones and await a further decision as to whether or not to actually clear customs for admission to the United States, or for re-exportation out of the United States to avoid the tariff liability. Of course, if you can't find any solutions for inbound shipments to the United States as a tariff action is taking effect, then we generally ask, or a general recommendation is for companies to consider pausing further shipments until they have a viable solution to the problem. So this leads us to discussion of medium-term strategies. Medium-term strategies, of course, would be to reconsider supply chains. If the Trump tariff action is hitting particular supply chains more severely than others, goods passing through certain countries, potentially there's an opportunity to think of diversifying suppliers to other places, or allocation of the cost of a sudden tariff increase. Perhaps that could be negotiated in advance, which party would pay, or how would you allocate between the parties. And then working with trade counsel and consultants. As these things are happening, you may need very quick assessment of viable alternatives, whether or not goods could be imported under, sent to an FTZ, or perhaps it's possible to find other strategies depending on how the implementation rules and regulations what those provisions contain. Sometimes they contain exemptions, sometimes they contain things that will potentially allow goods in exempt from those duties between certain dates. Those are things to consider carefully as these tariff actions take effect, sometimes with very short notice. I think the long-term strategy is, again, considered multiple sources, whether it's possible to have production, manufacturing in different countries sometimes that could avoid some of the tariff actions. The Trump administration's policy is to encourage U.S. production. So if that's feasible, whether some components or the final production for certain goods could take place in the United States, whether there's an applicable free trade agreement. There is not one between the EU and the United States currently, but perhaps other countries that have one, whether it's possible to have production take place in those countries instead, so that the goods will qualify for as originating from those countries and benefit potentially from duty-free or reduced duties for importation to the United States. And finally, we always suggest that companies think about opportunities to participate in ongoing proceedings in the United States, or trade associations that may present their views to the United States government as ways to try and counteract some of these sort of uncertainties going forward. So concluding, Dave, I think this is so as we discussed previously, IEEPA and other statutes that the Trump administration has invoked could allow for the sudden imposition of tariffs with little or no notice. Companies that sell products in the United States, we generally suggest consider flexible contingencies for flexible supply chain options if those are available. As we discussed, importers should review customs practices to see whether or not they have been accurately describing those three key elements. That's tariff classification code, country of origin evaluation, and whether there are ways to potentially correctly reduce the tariff liability. At the same time, they would want to engage in that review with expert counsel or expert advice, because it could mean past violations that they also have to consider reporting to the U.S. government to mitigate penalties. Of course, if companies are because the rules are very fact specific, quite detailed, we generally recommend engaging in this review with the advice of trade consultants or counsel.
Thanks, Augustine. Just a couple of notes before we turn it over for questions. I think for those of you, in the business community, trying to keep track of this all, you need to remember that things can change quickly because of the authorities that are being used. In fact, they can change day to day or week to week, rather than month to month, as you would typically see under U.S. trade policy in normal circumstances. And also at a very broad level, these tariffs can be implemented on a country-specific basis, like we've seen under IEEPA with Canada, Mexico, and China, or they could be implemented on a product-specific basis, such as the 232 duties with respect to aluminum and steel imports into the United States. So with that, I think we're ready to take some questions, and I'll just preface that by saying that we can't provide legal advice on this webinar, and so we can't answer detailed questions, but we can take some questions, sort of broadly about how these tariffs work and how they might impact businesses.
Dave, thanks for that segue. So we already have some questions in the chat. Someone had asked, what are the implications of the U.S. when the importer is a U.S. citizen? Well, the tariffs are imposed regardless of the citizenship of the importer, so that wouldn't affect the citizenship of the importer itself would not generally affect the the tariff rate. Rather, they look at the origin of the product into the United States. So that's based on a rule called substantial transformation. Under tariff law, that's the last place where a good underwent a change in name, use, and substantial transformation. And if there is an applicable trade agreement, then they look at the rule of origin under the trade agreement to see whether or not it qualifies under as the origin of that country to receive tariff preferences. And then there's another question, which is, does the U.S. president's tariff exemption for steel products processed in another country from steel mills imported in the United States apply to scrap metal? That's, again, one of those specific questions that would depend on the nature of the product. And so we wouldn't be able to address that here. We would have to, if someone has specific questions, we can discuss that after the call. But however, the tariff action as ruled out yesterday does suggest that there would have to be reporting of steel content, aluminum content for certain kinds of derivative articles, but you would have to look carefully at the tariff classification code as specified in those regulations.
And Augustine, I see one question here, whether there's any intention to put tariffs on EU lumber products, in particular engineered wood products. So this is a good question just in terms of the framework under which these tariffs are being imposed. I mean, the short answer is yes. In terms of lumber products and wood-related products. What we don't know under the Section 232 investigation of lumber is whether and to what extent that'll reach what we refer to as derivative products, so products made of wood that are manufactured into another product, such as what this question calls an engineered wood product. We don't know to what extent any trade relief that is imposed or any trade restriction that is imposed might reach things like furniture or other processed wood-based products, paper, things like that. And that's on the 232 side. And then obviously the reciprocal tariffs, if they were imposed on EU products, could absolutely, I would expect that there will be reciprocal tariffs based on country of origin under the reciprocal tariffs. Now, the size of those tariffs and to what products they will apply, we don't know. And we'll have to see how things develop under the reciprocal tariff process.
So there's a question about software. Well, software, generally speaking, is not subject to U.S. tariff by itself if it's transmitted electronically. However, if it's embodied in some physical medium, then potentially the physical medium could be subject to tariff. But again, this is something that's kind of speculative. It would have to be something that would have to be examined on a product by product basis, and not something we can discuss here without seeing what the product is, etc.
Thank you. Thank you very much, both Augustine and Dave. If I could just also intervene a little bit with some questions I've got from before we were at the seminar. One of them is really related to the one you've just answered, and that applies to the whole services sector. The people want to know whether we are only talking about the sector of goods and whether the services would be impacted by the tariffs.
So broadly speaking, the answer is no, not directly, in the sense that U.S. customs tariffs are imposed on the importation of physical goods. So what we've been discussing today are U.S. customs tariffs imposed under Title 19 of the U.S. Code, and those are imposed on the act of importing physical goods into the United States. However, as discussed before, the first Trump administration did commence a Section 301 investigation of the EU's policies with respect to digital services and taxation. So that could serve, if they were to revive that investigation, that could serve as a grievance, as a basis for the United States to impose tariff actions on EU goods for the purpose of removing those alleged obstacles. So it wouldn't necessarily be a tax imposed on digital services, but there could be a tax on EU goods for the purpose of negotiating with the EU to remove those alleged obstacles with respect to digital services.
Got it. Thank you. One more question before we turn to some of the more questions that came in the chat. Is it a purely federal competence, or do we also, or the exporter should also look at different state legislation or state action on this area?
So go ahead, Dave.
Yeah, so the tariffs are at the federal level, and states have almost no authority to implement taxes or tariffs on imported products into the United States. There can be different sales taxes that could impact foreign goods, but as a general matter, the tariffs themselves are at the federal level.
That's right. So, so an export sale to the United States could be subject to two different types of taxes, right? There will be the import duty that's collected by the U.S. federal government, by CBP, my former employer. And if it's a sale to a certain person in the United States, that person's place of residence, domicile, could have a separate sales tax. And every state in the United States has its own sales tax. So there could be two layers of taxation, one by the federal government, and one by the state government.
There's a good question in the chat about shipments en route to the United States before a new tariff announcement, whether they'll be subject to the new tax. And it says, we urge the United States not to impose tariffs, taxes after for goods already en route. So we don't know exactly how any new tariffs will be implemented, but we can just provide a couple of guideposts based on what's happened with the prior tariffs we discussed earlier. One is that, like in the Section 232 case, if you just look at the aluminum and steel articles coming from the EU, there was a grace period. I mean, there was a month notice, roughly a month, I might be getting that wrong, but something like a month from the date that the change was announced to the date of implementation under US law. Now, that's slightly different than what this question asks, which is if something's en route, because it can take, 60, 90 days, depending on the logistics and freight and ships and that sort of a thing. To get to the United States, there was, with respect to China, a narrow exemption for goods en route to the United States prior to the announcement of the new tariff. But it was fairly narrow in that the exporters and or importers didn't have much time, something like a few weeks, maybe a month before it went into where that narrow exemption could be invoked by the importer. And so there was some grace period for people who had already sort of sent stuff from their factory to the United States to avoid the new tariffs imposed on China. And I think we would expect something like that for future announcements. But Augustine, do you see things differently or have something to add? Go ahead.
Thanks, Dave. So that we found that there's been no consistency, right? So as Dave said, for the proclamation on the expansion to the steel and aluminum tariffs, that proclamation was issued about a month ago. So to the extent that a company could respond to that in time to decide whether or not to ship goods to the United States, that's helpful. But it wouldn't necessarily help someone who's already has a shipment en route that will arrive in the United States after the tariff takes effect. Occasionally, as Dave said, the Trump administration has scaled back or issued these partial exemptions for goods that are already en route, but there's been no consistency. It is not clear why it's issued in one time and not in another. But there potentially could be opportunities to comment to the extent that the Trump administration is amenable to receiving public comments, and that is something worth presenting to the U.S. government potentially, whether through comments or through trade associations, to sort of remind the U.S. government that there are these that these tariff actions are creating stress for members of the trading community who did not anticipate them. But that's something that will have to be discussed sort of on a case-by-case basis because there is no general policy that favors exemptions for shipments en route.
Thank you very much. And we seem to have exhausted the questions, and it's also now almost at the top of the hour. So I would just like to thank you very, very much, Dave, Augustine, for joining us for this very productive conversation. We of course understand that we do not know all the answers to all the questions. Maybe some we even don't know some of the questions yet. The next days will show where these questions will be coming from. But at the same time, again, I hope at least some of the questions were answered, and I'm sure they were. So thank you very much again for this connection. Have a really good day on the US side. Have a really good evening on the Lithuanian side. And until we meet again, iki kitų susitikimų. Ačiū labai.
Thank you very much.
Thank you.